Imagine the distress of realizing that what you thought was a secure real estate investment turns into a legal nightmare. Real estate, while a lucrative investment, is not without its challenges. From ambiguous contracts to unforeseen disputes, the legal landscape can be treacherous. Let's navigate the complex terrain of property law, exploring the common pitfalls, legal safeguards, and strategies to ensure your real estate journey is marked by protection and not litigation. This is Property Law Pitfalls, Avoiding Disputes and Maximizing Protection. Keep watching. A brand new episode of You and Your Money starts now.
You and Your Money is brought to you by J.S. Johnson.
Welcome to You and Your Money, everyone. Joining us today to talk about contractual clarity, navigating real estate agreements, is the founder and legal counsel of World Legal Services, Mrs. Tanya Wright. Tanya, welcome to the show.
Happy to be here, Ria.
Now, Tanya, I want us to get started by, let's just talk about what are some of those key elements that should be explicitly stated in a real estate contract to ensure clarity and avoid misunderstandings.
Well, real estate agreements for sale tend to be standard, but they can be customized for the peculiar transaction that it pertains to. But one of the things that we stress to our clients is to make sure that the agreement between you and the purchaser, the vendor and the purchaser, is crystal clear. So you would have to know, for example, the purchase price, whether or not it's a net price or a gross price, who is going to be responsible for the various fees and charges that will arise under a real estate contract. So those are the preliminary things that you must have a clear agreement towards before you should embark on a real estate contract.
Now, you mentioned net and gross. Now, what's the difference between net and gross?
Well, the difference between net and gross is when you agree to a price, you are either agreeing to have all of the fees, expenses, and charges, some of which are shared between vendor and purchaser, deducted, your portion deducted from the purchase price. That would be a gross transaction. Where none of the fees are expected to be deducted from, for example, the purchase price, that would be a net, which means that the purchaser, the vendor, wants exactly what the agreement for the sale of the property is. They want that back in their pockets. They don't want to pay any additional fees and charges, but on the gross, those fees and charges are deducted.
Okay, thanks for that. What are some of those common mistakes or omissions in real estate agreements that can lead to disputes, and how can these be preemptively addressed?
Well, as I said, the agreement between the vendor and the purchaser is key. They have to understand what the basic terms of their contract are. And so one of the things that we stress to them is make sure that you do come to an agreement on the gross or the net. You also have to come to an agreement on special terms. So if the vendor has to do certain things before the matter can close to please the purchaser, those items have to be spelled out in the agreement for sale.
And how does the ambiguity in real estate contract impact the legal enforceability of its terms? And what are those steps that parties can actually take to eliminate ambiguity?
Well, uncertainty of contract terms is one of the ways where you can avoid having to perform your obligations under the contract. Mm-hmm. Now, there may be certain terms that are uncertain, and those terms may not be enforceable. So the point is that one uncertain term or clause may not necessarily affect the entire enforceability of the contract. It really depends on how material that term is to the contract. So there may be a clause that is uncertain as to maybe the completion date, or one or two of the minor obligations of either the parties. But if the term as to the purchase price is uncertain, or the terms as to the description of the property, or another significant term in the contract, it is possible that that contract might not be enforceable.
Now, as a potential buyer, what are some of those standard fees or taxes associated with real estate purchase transactions? And are there any unexpected costs that should be considered?
That's an excellent question. We see this all the time. Of course, you know that there could be realtor fees, there will be attorney's fees, and there will be fees associated with value-added tax and other government charges. But oftentimes, and it really is not uncommon that you are well within the process of the agreement for sale, and other fees prop up. Let's say, for example, if the vendor has to ensure that stakes or boundary markers are in place, depending on the purchaser, whether the purchaser is financed by a bank, they may require that to be certified by a licensed surveyor. Okay. And so therefore you will have those fees will come up that may not have been contemplated in the original agreement for sale. There are other fees related to the property itself. For example, real property tax, which we know is a government assessed tax. And oftentimes people joke about the fact that the government doesn't come after you for real property tax. But there's a good reason for that, because they know their money is good. You try to do anything with that property, sell it or encumber it with a further mortgage, all roads lead through them. So they're going to get their taxes in any event. And sometimes they use that opportunity to do a reassessment of the property. And so you might find that the value of the property may have spiked, leading in an increase in real property tax charges that you might not have encountered before. So there are a number of things that can arise through the requisitions. If the vendor's lawyer says, well, there's something wrong with the root of documentary title, and other documents need to be prepared in order to correct that, that might also be subject to fees that was not factored into the original percentage of the purchase price fee that a lawyer, for example, might have charged.
Wow, there's so much to consider when you're thinking about a purchase price or having to actually purchase a property. Now, how can legal professionals assist in drafting or reviewing real estate contracts to ensure that they are legally sound and protect the interests of all parties?
Well, a lot of the precautionary work can come from an attorney who is experienced in the industry of land transaction sales, and they will know how to foreshadow fees and charges or other obligations that may come up. Okay. And it is not unusual for certain attorneys to actually tailor their agreements for sale to anticipate these things that sometimes are not included in a contract. But the key is to get a firm written preliminary agreement between the vendor and the purchaser, so that when you sit to prepare your agreement for sale, you will know if there are any special conditions that form a part of their original agreement. There may be clauses as it relates to furniture, for example. There may be clauses as it relates to other items that are in or about the property. Maybe certain trees. I've seen transactions where certain unique trees were not a part of the transaction. But the terminology that is embedded in the contract, they have stood the test of time once the attorney is fully aware of the original agreement and what means the most to the parties. Because we sometimes think of terms as being standard, but there may be some provisions that go to the root of the contract or the original agreement between the purchaser and the vendor. And the attorney must be very cognizant to make those terms really important and emphasized in the contract, so that would be an underlying term of the contract.
Wow, it's interesting to know that you can actually go ahead and list special trees in your agreement as well. Tanya, we have to take a quick break. When we come back, we're going to look at legal strategies, dispute resolution. This is You and Your Money. We'll be right back.
Throughout our lifetime, we must all make decisions. No matter how we choose, the right one just needs to be made. Like having J.S. Johnson Insurance Agents and Brokers as your insurance partner. We've been serving the Bahamas for over 100 years. Whether you need home, motor, marine, or commercial insurance, make the right decision. Call 397-2100 or visit jsjohnson.com.
JS Johnson Insurance, peace of mind.
Get ready for the 25th Grand Bahama Business Outlook, February 22nd at 8:45 at the Grand Lucayan Resort. Keynote address by DPM the Honorable Chester Cooper and a powerhouse roster of speakers, including the Honorable Ginger Moxie, Shakira Johnson, Rupert Hayward, Dennis DeVoe, James Carey, Lynette Fowler, Juan Hernandez, Ian Roll, and many more. Secure your spot today at tclevents.com.
Welcome back to You and Your Money. Still here with us is the founder and legal counsel of World Legal Services, Mrs. Tanya Wright. And in this segment, we'll be discussing legal strategies, dispute resolution. Now, Tanya, when a real estate dispute arises, what are the advantages and disadvantages of pursuing mediation as opposed to litigation, and how can parties decide on the most suitable approach?
Well, dispute mediation is always an option. In terms of advantages or disadvantages, the advantage is supposed to be reduced cost. Okay. And oddly enough, the disadvantage can also be increased costs. The way that we try to mitigate against disputes, first of all, we have to determine what the jurisdiction of the contract is, and it will invariably be the jurisdiction of the Commonwealth of the Bahamas. In that jurisdiction, you do have an option of mediation and or the Supreme Court. Your contract should state if the parties agree that mediation should be a viable option, they should have a clause embedded in the contract for mediation as a means of dispute resolution. Otherwise, it will more than likely end up in the Supreme Court, in the civil proceedings in the Supreme Court.
Now, what legal mechanisms or clauses can be included in real estate contracts to prevent disputes from escalating, and how effective are these in practice?
Well, there are a few clauses that make provision for example, if the transaction does not close, one party, and it's the fault of one party over the other. Those clauses tend to recite the rights, what each party might be entitled to in the event it doesn't close due to the other party's fault. So that might mean that if it is the purchaser or the vendor, they may have a right of something that we call specific performance, where they may have a right to force the other side to complete if completing the contract is ultimately what they want. Both parties, in the event of a dispute, might decide that they both want to walk away from the contract. One might decide, well, listen, I have suffered as a result of your not being able to complete, and therefore I may be entitled to damages. That will be embedded in the contract to say, in the event that this happens or it does not happen, the other party would be entitled to damages. But one of the major safeguards is how we treat any deposit that's payable under the terms of an agreement for sale. And a party at fault who does not wish to complete, if it is the purchaser, might find himself or herself having to forfeit the deposit because of their failure to complete. And likewise, if the vendor, who invariably will be holding the deposit through their attorney, may have to return the deposit if they, for some reason, are not able to complete.
Tanya, how does the enforceability of dispute resolution clauses in real estate contracts vary, and what factors can impact their effectiveness?
Well, we already discussed the major factor of uncertainty that might affect the enforceability of a clause. If you can't understand what the true intention of the parties was at the outset, it may hinder your ability to complete. There may also be some other factors. For example, if the fees and charges may have increased exponentially because of, for example, outstanding taxes or reassessed taxes or other fees or charges that were not within the contemplation of either parties, to the extent that it would have changed the nature of the agreement. That might be something that would affect the ability of the parties to complete. And sometimes you have the full agreement of the parties to back away from the transaction. Another thing is, of course, an act of God. If the property were to become damaged or substantially damaged to the extent where it might have been destroyed, you know that we have a climate in the Bahamas that is susceptible to hurricanes and storms. So there may be instances where an act of God may intervene between the commencement of the transaction and the completion. Terms are built into the contract to allow parties to exit the contract if the damages exceed a certain amount. And another thing too, we always put an insurance clause in there so that, yes, some damage might happen, but if it is done, if it happens because of an insured risk, then there may be insurance to repair that damage so that the transaction could complete. But act of God is something that we always try to plan for, and there are standard terms that there's a term for that is standard in almost every agreement for sale that you will encounter.
Well, in what ways can legal professionals facilitate resolution of real estate disputes, and what strategies do they employ to achieve favorable outcomes for their clients?
One of the best ways that they can do that is to talk to each other. Okay. The attorney for the vendor and the attorney for the purchaser must be able, as the persons with the legal mind and the people who have the best appreciation for how the conduct of their clients might impact on the closure. And so we need to talk to each other. If there are instances where there might be some uncertainty as between attorneys, we may be able to discuss it and determine that it is not material, and can take that advice to our client so that they don't have to get involved with each other. And we actually are the principal mediators, and we should be the principal mediators for these contracts. We have drafted them. We have drafted them in agreement with each other, because a contract is drafted by one attorney, sent to the other for them to approve, to make sure that their clients' interests are best protected. And so once the line of communication between counsel during the course of the transaction is free-flowing and there is good faith, disputes tend to be we're able to avoid disputes without it even getting to our clients. So that would be one of the main things that attorneys can do: make sure we talk to each other to make sure that while we are protecting our clients' best interests, we also want to do what we can to save the transaction and bring it to completion.
It's definitely clear as to why it's important, it's imperative that you have legal counsel to assist you while you're going through these kinds of transactions. Tanya, we have to take another break, but when we get back, we're going to talk about navigating landlord-tenant relationships. This is You and Your Money. We'll be right back.
Get ready for the 25th Grand Bahama Business Outlook, February 22nd at 8:45 at the 𝗪𝗓𝗧𝗪𝗓𝗧𝗔 Resort. Keynote address by DPM the Honorable Chester Cooper, and a powerhouse roster of speakers, including the Honorable Ginger Moxie, Shakira Johnson, Rupert Hayward, Dennis DeVoe, James Carey, Lynette Fowler, Juan Hernandez, Ian Roll, and many more. Secure your spot today at tclevents.com.
Wake up, wake up, wake up dead early with Bahamas at Sunrise on RTV, channel 212. We're live at 6:30 a.m. on Mondays and Fridays with rebroadcast at 8 a.m. on Mondays, Wednesdays, and Fridays, and also at 9 a.m. on Saturdays. Man, Bahamas at Sunrise brings you everything. We got weather, fashion, food, politics, current events, music, and more with your hosts, Mark Daniels and Gabrielle Gardner. Tune in to Bahamas at Sunrise dead early, the best in Bahamian morning television.
Throughout our lifetime, we must all make decisions. No matter how we choose, the right one just needs to be made. Like having 𝗖𝗛𝗥𝗘𝗧𝗏 Insurance Agents and Brokers as your insurance partner. We've been serving the Bahamas for over 100 years. Whether you need home, motor, marine, or commercial insurance, make the right decision. Call 397-2100 or visit jsjohnson.com.
S. Johnson Insurance, peace of mind.
Welcome back to You and Your Money. The founder and legal counsel of World Legal Services, Mrs. Tanya Wright, is still with us. In the previous segments, we spoke about contractual clarity, navigating real estate agreements, and legal strategies, dispute resolution. In this segment, I want us to talk about navigating landlord-tenant relationships. Tanya, what legal rights and responsibilities do landlords and tenants have, and how can understanding these rights contribute to smoother relationships and prevent disputes?
Well, just like in a transaction for the sale of land, most landlord and tenant relationships are governed by a lease document. And so you have in the agreement for sale, the terms and the obligations of the vendor and purchaser are all laid out in the agreement for sale. In a lease contract, the terms and the obligations of the landlord and the tenant are laid out in the lease document. Again, lease documents, like agreements for sale, tend to have standard clauses that are in every lease, and you just tailor it depending on the nature of the relationship with the particular parties involved. So there are standard obligations the landlord would have because they actually still own the property. So they have the obligation to insure the property, to make sure that all of the taxes are paid up on the property. They have the obligations of an owner. The tenant, for example, will always be expected to keep the premises neat and tidy and in a habitable state. And of course, the big thing is the landlord expects to be paid a rent, and the tenant must pay that rent. Sometimes you have special terms where the tenant pays a little more than the rent or may be responsible for additional charges. But again, that is something that should be contained in a lease document. Oftentimes you find that there may not be a lease document, and then certain problems might arise.
All right, so you kind of started to talk about some of those key components. I want you just to elaborate if there's anything else that should be included in a lease agreement to protect both the landlords and tenants legally, and how can potential pitfalls be addressed proactively?
Well, the lease document is a contract. And every contract, whether it's a lease document, an agreement for sale, or some other commercial document drafted by a competent attorney, will have terms embedded in their standard documents that take care of the minimum expectations of the obligations between the parties. And they will have a jurisdiction clause to say that the disputes would be resolved in accordance with the laws of the Commonwealth of the Bahamas. They may also have an arbitration and mediation clause where the parties agree that arbitration or mediation should be an option for resolving disputes. There will also be clauses, as in the agreement for sale, where they will say what the penalty is for failure to comply with any one or more of your obligations under the lease. For example, a tenant has to pay rent. In the lease document itself, it will say what the consequences will be if you fail to pay the rent. So some of the standard expectations of landlord and tenancy agreement will be contemplated And so, and because they are material to the contract, the properly drafted contract will already have the mechanism in place for the remedy for the breach, so that it leaves no doubt as to what you're exposed to if you don't comply with your obligations.
Okay. And what are those legal protections for tenants regarding to privacy, and how can landlords strike a balance between property inspections and respecting the tenant's right to privacy?
That goes right back to the lease, Ria. And as I said, the lease document is the Bible of the relationship between the landlord and tenant. I have seen leases where the landlord reserves to him or herself the right to inspect properties upon the occurrence of certain events. And if it is in the lease document, it should not take the tenant by surprise to know that an inspection might be due. There is also or there should be in all leases, a provision where that inspection should be subject to providing reasonable notice to the tenant, to give them an opportunity to put their affairs or their personal effects in a manner where their privacy would not be adversely infringed upon. But again, it depends on the terms of the contract. Most landlords will reserve that right at different stages throughout the tenancy. And if you enter into that lease, you sign the document, you are assumed to have read and accepted the terms of that, and therefore you cannot complain if the landlord decides to exercise that option upon giving reasonable notice.
Well, Tanya, before you go, let us or let our viewers know how they can get in contact with you. I mean, you shared so much valuable information here with us today. Let our viewers know how they can get in contact with you.
Well, you can visit my website, wls-law.com, and I have included in there all of the products and services that we offer, and a mechanism for you to contact us directly through the website at your convenience. But I would, even if it's not for contact purposes, there's a lot of information in there, including what I've shared with you today, Ria. And I think that there are other areas of the law where anybody who's interested in clicking onto a particular topic will be able to at least whet their palate in their quest for further information on the law.
Wow. Well, thank you so much for joining us on the show today.
My pleasure.
By understanding the risks and implementing protective measures, you can navigate the intricacies of property law successfully. Remember, informed decisions and legal awareness are key to ensuring that your real estate ventures are marked by security and prosperity. Stay vigilant, stay informed, and may your real estate journey be one of safeguarded success. Before you go, we want to hear from you. We want you to scan the QR code on the screen to give us your feedback. Thank you so much for joining us, and until next time, invest wisely. Here are our dollars and cents snapshots from this week's show. Number 1, document diligence. Ensure meticulous documentation of all real estate transactions, contracts, and agreements to avoid potential legal disputes down the line. Number 2, legal checkpoints. Regularly consult with legal professionals specializing in real estate to conduct periodic checkups on your property holdings. Number 3, educate yourself. Understanding the legal landscape will not only protect your interests, but also empower you to make informed decisions throughout your real estate journey. Well, that's it for today's show. And don't forget to scan the QR code on the screen to give us your feedback. Follow You and Your Money on Facebook and tune in next week for a brand new episode. I'm 𝗲𝗓𝗡𝗖𝗓. Thanks for watching, and I'll see you next time.